recorded. So welcome everyone. My name is Ann Badmus. I'm the managing attorney at Badmus Associates, and I want to thank you for joining our webinar today, which is EB-1A Extraordinary Ability Visa, Building a Winning Petition in 2026. Sorry, just trying to get this down here. Okay, so before we get started, I just want to remind you all that while we want this information or the information that we're providing to you to be helpful, please know that the information is not legal advice, because as attorneys, we need to understand your specific case details and background to properly advise you. So everyone here on the call and viewing is unique. So while this information is intended to be an education so that you can understand generally how EB-1A cases are treated, please do not rely on it alone in your specific matter. So we have quite an agenda for you today, quite a bit of information we're going to cover. By the end, we hope that you will understand what the USCIS is looking for in terms of EB-1A applications or petitions, and actually give you some information about a recent court case that could change the way in the future that the government evaluates and decides these types of petitions. But quick housekeeping note before we move on. Please remain on, you are muted, so please remain on mute, but feel free to ask any questions in the chat. But if you do that, please abstain from indicating any personal details, because we do want to maintain your confidentiality. This is a public forum, and so we want to make sure that you are not disclosing information that you might not want to be known in the public. This webinar is recorded and will be available on our YouTube channel. We will also send you a link as well, and we will share the slides with you. So let's start with the first part of our agenda, setting the stage. So basically what we want to talk about here is, what is an EB-1A? At a glance, what does it offer? Why do we want to consider an EB-1A as part of our process if we're interested in getting permanent resident status? So first of all, as I mentioned, EB-1A is a permanent resident application. So if you are approved for EB-1A, that means that you're on track to receive permanent residence, which is a green card, as known as a green card. And then in the future, of course, you are eligible for citizenship as well. So it is a very valuable type of petition. It would end all need for any visas in the future to remain in the US. So we want to talk about what the benefits are of an EB-1A. So one key benefit is that, unlike other employment-based green card applications like a PERM, Department of Labor application, and a few other types of applications, you do not need to have an employer sponsor you. So this is what we call a self-sponsored application, which basically means that you can file on your own the application itself, which initially the actual application is called the I-140 petition. So you as an individual can apply on your own, whether you're here in the US or even outside the US, you can actually apply on your own. Another advantage to that, another aspect of the EB-1A is that you skip that PERM requirement, as I mentioned before. So again, you don't have to have an employer, you don't have to prove like an employer typically would through the labor certification process that there are US citizens, or there are not US citizens or permanent residents that can do the job that you plan to do. Another advantage is the priority date. So there are a limited number of green card applications based on employment available each year. So as a result, and that is determined by the category of green card that you're applying under, and it also is determined by your country of birth. So generally, EB-1A is considered what's called a priority worker category. So it is at the top or the very front of the line for these green card applications. So if you have an EB-1A, you are given priority over others who are in a different categories. So right now, and in general, usually for EB-1A, it is current as far as priority date, which means basically there's really no waiting time or queue for EB-1A for most nationalities. However, for those born in India or China, there is a slight backlog or waiting time, but it is usually the fastest category for those who are from those countries as well. So if we're looking at also the fact of the matter is if we're actually looking to apply for EB-1A with all these benefits, it is a high bar, meaning that it does require quite a bit to be able to qualify. But of course, the reward is if you do qualify, you get the benefit of permanent residence as well. So it does require a high level of accomplishment, which we'll talk about in a minute. But some more background as far as EB-1A is what we're seeing now in applications that are being submitted with and how they're with the USCIS, which is the agency that reviews these applications. Is part of the Department of Homeland Security. So just want to give you a little data on what we've learned from the published data that the USCIS gives out as of last year, 2025. So there appears to be an increase of EB-1A applications, 50% year-over-year increase. So last year was 50% more than 2024, which makes sense because it is a highly valued type of process where, especially if there's not employer sponsorship, or if you're in if you are from India or China, it's going to be a faster category for you. So we will see that. So what we understand from the data is that the filings, country-specific filings from India and Nigeria are actually rising quite a bit, whereas filings from those born in China have declined. But it is very competitive. As you can see, there's a lot of people applying for EB-1. And but when we understand from the data, 67% is the current approval rate, which is less than it was previously. So in 2025, as compared with 2024, the approval rate is 67%, whereas it was about 73% in 2024. And so this is EB-1As. There are other EB categories. So sometimes when you see the general data about EB categories, it looks a lot higher, but that's because the other categories like EB-1B and EB-1C, which are employer sponsored, tend to have a very high approval rate. But if you look specifically at EB-1A, which is self-sponsored, it's about 67%, so significantly less than those other EB categories. In addition, just wanted to mention the statistic about O-1A. So O-1A is a temporary visa, which has very similar criteria to EB-1A, and that approval rate for O-1 is much higher. We're seeing 90% or so of O-1A approvals. So oftentimes we have clients that get O-1A and they, ask whether that's going to, convert to an EB-1A, and there really is no conversion, even though the criteria is very much the same. The evaluation and the way the government looks at EB-1A is a higher standard of evaluation than it is for O-1A. So if you have O-1A, it's a good start, but it doesn't automatically mean that you will get an EB-1A approval as well. So, but it could be a good option. If you have O-1A, you can still maintain that while you're in the process of applying for EB-1A, or if you're trying to come to the U.S. faster or have a need to change your status while you're in the U.S., you might consider going with O-1A first before applying for EB-1A. So what this means for people, as far as these statistics are concerned, is that we are seeing, well, the government is seeing more cases. Officers are having more cases to review. So there's, thousands and thousands of cases. And in addition to EB-1 cases, officers review a lot of different cases. So you really need to make sure yours stands out among all the many, many cases that they're seeing every day. We also are expecting, as far as changes or potential changes in the way that EB-1A applications are viewed under the USCIS. We are expecting don't know yet. This is just a prediction. We won't know until it actually happens. But the USCIS might be issuing new regulations or new policies that they'll talk that we don't know again what it's exactly going to be, but just considering the way the administration is currently doing things with all types of applications, we would imagine that they're trying to make the level of or the criteria harder to meet than we've seen in the past. So we do expect that sometime this year, hard to tell, but typically the way it works is that the government will issue regulations and have a time for comment. So we'll kind of get a preview, and then the public has a right to comment and let the government know what it thinks, and then finally it'll be finalized as well. And finally, the last thing that we're seeing currently outside of these potential for regulations is that RFE, requests for evidence rates, are much higher. And it's pretty much across the board about any application, but in particular with EB-1 applications, we are seeing more and more RFEs. Now, that means, of course, that you want to make sure that when you apply, you provide a very comprehensive application to reduce the possibility or likelihood of an RFE. But even in those cases, it is possible to get an RFE. So you just do your best to present the case and be prepared to maybe have additional information or be prepared for an RFE and be able to address that as well. So now let's talk specifically about the EB-1 and the criteria for that as it stands currently. So as many of you may know, the EB-1, like EB-1A, in addition, there's other, even EB-1B and as well as EB-2 national interest waiver, have what's called a Kazarian two-step framework. So this is how the USCIS officers are told to evaluate EB-1 applications that they receive. So Kazarian dates back about 10 years, maybe a little bit more, in terms of a case, a lawsuit that was filed, and out of that lawsuit, a court made their ruling, and they kind of talked about this two-step framework, which is named after the case, the actual petitioner or the person who the EB-1 applicant's name was Kazarian, Dr. Kazarian, and he filed a lawsuit against the government. And the result of that lawsuit now was used by the USCIS as their standard for evaluating cases. So what the Kazarian case said was that the first step would be determining whether or not the applicant or the petitioner met at least 3 out of the 10 criteria. So that's the first thing the government does, is looks at the criteria, looks at your evidence, and says, do you meet at least 3 or more of those criteria? If you do, if you don't meet those, then they will probably issue an RFE. They believe you don't meet those, they'll probably issue an RFE, and you have an opportunity to present additional evidence to try to meet those meet at least 3 criteria. But even then, after even if they found that you did meet the criteria, then they have what's called a final merits determination, which is a very subjective evaluation where that officer, looks at it and says whether or not they believe that the overall package of evidence you provided shows that you're truly at the top of your field. The problem with this second step is that there's really no specific published criteria that we, as the public, or those who want to apply for EB-1, understands or knows. What does the officer look for as far as the final merits determination? So as a result, you often get decisions where, yes, they find that you meet 3, 4, 5, maybe even 6 criteria, but for some reason in their subjective mind, mysteriously, they decide that, no, you do not meet the final merits determination, and they deny your application itself. So it's important to know this because, of course, this is, what the way they evaluate it. But it's really, really important to develop your evidence considering both of these steps, step 1 and step 2. But I will talk about a recent case that may be a challenge to this step 2 based on many legal aspects of whether or not the government is actually complying with the law in terms of how they're evaluating cases. So we'll talk about that in a few minutes. So let's talk now about the 10 criteria, and this is a pretty quick reference about that. So I'm just, in the time we have, we cannot go in depth into everything, but as you are considering or preparing your applications, you want to look at definitely going through what the criteria is and determining whether or not you have or can find substantial evidence that will help you to apply or meet the criteria. So there's actually 10 criteria, and I like to say that, not all of these criteria apply to every field, every profession. So we'll address that as well. But the first criteria is awards and prizes. So this means these are awards and prizes you have won, or the potential applicant has won, where this has been it's a competitive recognized prize, whether it's early career, even student competitions. You have to show or provide evidence to the government that this prize is considered nationally or internationally to be one of the top prizes in your field. It's not the Nobel Prize, because the Nobel Prize or Academy Award or those types of well-known international prizes. If you can get one of those, then usually you don't have to go through this criteria. But most people don't have those top prizes, so we have to look at this set of 10 criteria to determine whether they meet the EB-1 category. So I will say it's usually not typical to find many applicants who meet the standard of having these international or national prizes, but you definitely want to look and see if you have won any awards to really evaluate how recognized that award is, and if possible, or if you do believe that it does meet that criteria, definitely submit information about that. The second one is membership. So a lot of professionals have memberships in different associations related to their field of expertise. So, but it is not just a membership where, as long as you're in the field and you pay the fees, or fill out the application, you become a member. The membership criteria requires that the organization that you're a member of has a high level of membership criteria, where you must show that you have some outstanding accomplishment or achievement before you can be admitted into that membership. So pretty much things like honorary society, fellow level memberships, where it's a higher level of membership than the general membership, where you actually, again, have to prove some sort of achievement in order to become a member. So that's important as well. Publish media, number 3, publish media about you. So this is, first of all, you need to show the media itself. So the USCIS is trying to keep up with, the way things are now in terms of communications. In the past, they were thinking of things like newspapers, print, magazines, but now we have all kinds of communications, social media, digital publications, podcasts, all those different things that we now, most people probably use more so than print. So it's very important that if you do have that kind of media coverage, you still need to provide information about that media itself. Is it a major, what we call major media, meaning that it is widely disseminated, maybe it has a lot of views, a lot of subscribers, things like that, that you can show that it's not just one YouTube video that maybe had 100 views or something like that, and it was your own video. It would need to be a video that was published maybe by a national television station, or national whatever is out there in terms of that, or national podcasts, like a podcast that has a lot of viewership, and you were a guest on that, or they were talking about your work, that sort of thing. So it's very important to define the media, but also provide data to show how widely covered or widely disseminated that media coverage was. Number 4 is judge of the work of others. So this is typically considered for those who are maybe more in academic types of work, where there's journal publications and there's peer review, grants, conference programs, things like that. But it could apply across the board to any occupation, because you also, or any profession, because you also will have different, almost all professions, I believe, has conferences, has publications and usually wants to get feedback from those that they consider are, experts in the field as far as whether or not something, whether an individual or someone's project or someone's articles are actually worth publishing. So that judge of the work of others generally relates to peer review panels, grant committees, but there can be other ways. So you want to, if you're not really in that kind of field where that's a typical type of thing that people in your field do, think about, other things that might make sense. For example, if you judged a competition of like a CEO competition, they have those different types of technology competitions, things like that. You want to consider that if you were part of that, or you were part of a conference committee that determined who would be speaking at a national conference, then that could also be considered judge of the work of others. But again, you need to have evidence of those things to show that you actually did or were involved in those types of activities and did accomplish them. Number 5 is original contributions. So it's briefly said original contributions, but it's original contributions of major significance. So you have to show that it's some proven impact of the work or the accomplishments that you have done. This is really the hardest criteria to get to prove, mainly because it is pretty subjective. I mean, who would consider, how do you determine whether it's a major significance? Some of the hard data that the government likes to have so that they feel comfortable that it's major significance are things like if you publish, the citations to your work, how many citations do you have, how many downloads or views of your articles that you have, who has adopted your work, whether it's been, for example, if you're a physician, has it been clinically adopted throughout, have other clinicians adopted your work or use your technique or whatever you have determine or your research has been used in that aspect. You can also talk about if you have a patent, some proprietary licensing of your work. That could also be some hard data that the government likes to see. This is also where expert letters are important to provide context for the government to understand what your contributions are as well. The next criteria is scholarly articles. So scholarly articles means these are articles that are reviewed, vetted before they're published. So it wouldn't necessarily be an article where maybe you put it on a blog or something like that. This would be the situation where you have submitted to a journal. They go through a peer review process where other experts in your field will review your article and give its feedback. And then the editor of the journal decides they will publish your article. So having one article would be enough to meet this criteria. However, it's really, although I say quality over quantity, just having one article, unless it's an article that was cited 1,000 times, it may not be enough to overcome the final merits determination. So you should want to, if you're trying to go for this particular criteria, want to show a few articles or more. I don't really have a specific number because it really depends on each case, but you also want to, in addition to showing how many you have, you want to show the quality of it, which means you want to talk about the impact factor of the journals that you published in, or some other statistics that you can provide to show why this article, even though it may not have tons of citations, it's still considered to be a strong article as well. So the other criteria is number 7 is artistic displays. So this is one of those categories that's probably very limited in terms of which occupations or professions could actually use this criteria. So this would be more, as the name implies, it's more about those who are in the arts, the fine arts, or even art, any artistic endeavor where you are having a showroom or a gallery, you're maybe a museum or some different way of you having a display of your work, your paintings, things like that. So this again would be kind of limited to those in those specific types of fields. And I'll just jump over to number 10, just because it's very similar to number 7, which it also is probably more limited, the commercial success criteria for those who are more in the artistic fields, where you can show like acting or actors or any other types of fields where musicians, that sort of thing, where your commercial success probably could be tied to the streaming of your music or concerts, ticket sales, just basically showing that commercial success. So those are for those people in those fields, it's very important to provide that kind of information as well. So the final two we'll talk about, I'll start with the high salary. So salary, or it could be compensation, because sometimes some fields there's not necessarily salary. You may have received, quite a bit of, as a contractor, you might have received quite a bit of compensation as well. So, but what you have to do is to basically provide proof of your compensation, whether it's through a salary where from an employer confirming that, or tax data that you can do to prove that. And then the second step of that is to prove what we call the comparative data, meaning you have to show what is the typical salary in your field as determined by objective sources such as salary.com or the U.S. Department of Labor statistics, or if you're out in a different country where you're trying to show your salaries higher than average or in the top 10% or more in your country, then you're going to have to find that data where and it's usually a little bit harder in some countries to find that, but there are some out there, and where you want to get that published data to say, hey, based on this survey, my salary is in the top 10% or well over the average salary as well. And then the last criteria I'll cover is the critical role. So this, again, is another two-part kind of evaluation. First of all, you need to prove or show that the critical role in your employment or some organization where you're a part of the organization, that organization itself must be distinguished. It must be considered one of the top organizations in the field. So you would need to provide some proof, like the awards that the organization itself has won, or if there's top 10 organizations in your field and your organization is considered one of the top 10 or top 100. We often go to places like US News and World Report where they have those top lists, or Forbes, places that kind of categorize or determine how many or publish what is the top organizations in any particular field. So that's number one that you have to prove. And then the second thing is that you have to prove that your role within that organization is, or a department of that organization is one of the most important roles there. So that's going to be requiring a lot of information from or proof from your employer, who will either provide a letter or other information to show that you are currently, or have been, if it's a previous employer, have been critical to the operations, and if you're and showing that your contributions contributed to its reputation as one of the top organizations in the field. So those are the criteria. I know it's quite a bit, but let's go on now to what the evidence. Let's go a little bit deeper into some of the evidence that the USCIS really likes to see. So I'm just going to cover a few of these criteria. I might just kind of overview, but media. So I talked about before, if you have media coverage in those digital publications, podcasts, print media, all those things, they all qualify, but you want to make sure it's featuring you as a subject matter expert. You're interviewed, being asked about your work, asked about to give your opinion about other people's work, something to show that you have been considered so well recognized that you have gotten that kind of media coverage where you've been asked to do those things. Judging, again, as I mentioned before, there's different ways to prove judging, but if you can think about if you were part of conference program committees, grant applications, maybe you were startup accelerated evaluations, or other open source projects, reviews, that kind of thing, you can potentially satisfy this. I also should have put on here sometimes teaching. If you're a professor or you've been involved in some education programs about within your field, that could also be considered judging, because you'll be evaluating the students or the people who are in your teaching there. So the other two criteria, original contributions, these are as I mentioned before, is the hardest to approve. So again, you want to focus on adoption of your contributions, who has been using what you have contributed. If you have developed a new technique or a new software or something that has made an improvement in the field, then you want to show or provide evidence either from people who have actually purchased or used your work in some way to show, and for them to show how it's really been a game changer in the industry itself. Again, citation impact, licensing, those things, even though you say this is totally new, yes, it may be new and it may work, but if no one's adopted it or no one knows about it, then they're not going to consider it an original contribution. And then lastly, for awards, I did mention before, even if it's, you're still new in the field, however, you have won competitions that are national, like best paper at a national conference or some other kinds of national awards. And even if you were on and for team awards, that would be more again of those like athletic fields. If your team won an award, it can be considered an award attributed to you as well. You would need to show what your part in the team was, and maybe show some recognition for your part in that team effort as well. Okay, so next to talk more about that winning approach, as I mentioned before, there's really what you want to consider is the USCIS is putting greater importance on the quality and the relevance of your achievements over how many achievements that you have. So in the past, a lot of times people will apply and they're saying, oh, I've got, 3 or 4 of this criteria, 4 or 5 of this, or whatever. Those things, while they're great, you still have to provide that story explaining to the government why those achievements are important, why they give you national or international recognition. So you always want to make sure, don't treat it as a checklist of documents. You want to make sure that you're submitting evidence. When you submit evidence, you give the context so the government understands how that evidence relates to the overall picture of your recognition. So don't let the government try to figure it out, because they don't have enough time. They have very limited time, especially if you're going through premium processing. They have to churn those applications pretty quickly. They do spend probably more time with an EB-1 than they would for other applications with less information that's needed, but they still are very limited in time. So you want to make sure that you're connecting those dots for them and making it as easy as possible for them to say yes. So the winning approach would be, first of all, define what your anchor achievement is. What is the key thing that if you told someone you accomplished this, a stranger, for example, and they would say, wow, that is really amazing, or, a great thing that you've done, that would be what you consider to be your anchor achievement. Focus on that and then build around it using different criteria, the other criteria of EB-1, to see how that fits into that anchor achievement. So for example, if you did win an award, not a Nobel Prize, because like I said, you don't need anything else if you won that, but something that's similar or very well recognized in your field, then you could talk about, hopefully there's publicity around that. So with your award, you also received a lot of, articles, people wrote about you, did a lot of interviews, things like that. It also led to other people contacting you to learn more about your work and wanting to be a part of it, or to get your feedback. Those types of things. Asked you to speak at conferences, all those things that kind of can come from that achievement. It doesn't, that's that's an example there, but there could be other things similar to that where you want to focus on those things, focus on that anchor achievement and then build around that. And so your narrative would be connecting all that evidence and showing how there's you demonstrate that you've made an impact in your field, and compare yourself to others in your field who may not have accomplishment as much. So what you're saying, you don't necessarily have to be the very top, like no one has ever done anything like I've ever done, but you also want to show a distinction between yourself and others who are actually in the field working as you are. So I did mention earlier, I wanted to talk about a recent case, Majerky, I'm sorry if I'm not pronouncing it, Majerky versus Miller. And this is what we call the case that could change everything. We can't say it will, but it is a start that's positive in my view and a lot of attorneys' views. So what happened in that case? This is a court case. So of course, the USCIS is part of the executive branch. It's an administrative agency. The courts, the legislative branch, and the courts can require the executive branch to do certain things. So when someone's not happy with the outcome of their case, they do, in some instances, have the ability to file in court. And so in this case, the EB-1 applicant was an Indian journalist, and she filed her EB-1 application EB-1A application in March 2024. So not just about 2 years, well, 2 years ago. And so the USCIS in the first part of their evaluation said, yes, she met 5 criteria. So that's quite a bit, 5 out of the 10, well above the minimum requirement. But they still denied her application based on the fact that they thought that she didn't have sustained a claim like over time. And she just maybe had some accomplishments, but maybe no one knows her now. I guess that's what they're saying. And they said the evidence was too old. So she sued in 2024. And then court cases take some time. As you can see, it took almost 1.5 years. And the court in Nebraska actually did vacate her denial, which basically says, actually told the government, you cannot deny this case and you actually have to approve, which is really kind of interesting, really unusual, because typically it can, usually the courts will say, we don't think you follow, if they agree with the plaintiff, the person suing, that the government did not comply with the rules, then they will usually tell the court, I mean, the government, okay, well, you need to go back and look at this again and potentially make a different decision or justify in a different way why you denied this case. But in this case, the court actually required the USCIS to approve. So they did not give the USCIS the opportunity to come back and say anything different or try to justify their denial in a different way. So that was very, very interesting and great work, and great that she was able to get the approval based on the court saying that she must be approved. So just to dig a little deeper into what happened there, why that is important, is that the court, what the court looked at is how did the USCIS treat this application? And the court said from 1991 to 2010, so this is when 1991, many years ago, that's when EB-1A started to be a process for people to apply for a green card, until 2010, according to the congressional law, meeting 3 of 10 was sufficient for approval. And in 2010, I've actually thought it was 10 years ago, but it was more like 15, almost 16 years ago, that the USCIS in 2010 decided to use that Kazarian framework that I mentioned earlier. And so the court said that was not a lawful way for the USCIS to implement this kind of rule. They did not actually go through a formal procedure where they should have told everyone at that time, this is how we're going to do things. You have the opportunity to comment, and then we're going to make an official rule. So they've never really, for the past 15 years, had an official rule. They just said as a policy, this is how we will determine EB-1A applications. The other fault of the USCIS that the court found was that second criteria, or that step 2, the Kazarian, final merits determination, really, as I said before, it was not clear. There's no defined standard. No one knows how the government is determining whether or not someone meets step 2. And so without that, that is really a lack of due process. If you want to talk constitutionality, there's really no due process for anyone who wants to apply to understand how they can even meet that criteria. So as a result, there's so much inconsistency and, no standards for anyone to know. So those are the two reasons that the court found that the case that the USCIS is wrongfully using the Kazarian standard in order to adjudicate cases. Now, it doesn't mean, unfortunately, that the USCIS will automatically move to that, and I'll talk about that in a minute. But I also want to address what we call the case that the court has of the Supreme Court, where they overruled the Chevron deference. So what that means is, and a lot of legalese, I won't spend too much time on this, but basically in the past, when federal government agencies were sued and they went and the courts would say, or the Supreme Court said, oh, well, we usually want to defer to the agency, unless they were totally off base, we're not going to overturn anything that they decided. But last year, or 2024, the Supreme Court kind of changed that and said, no, we can actually substitute or look at these things independently. And if we believe that the government agency, whatever agency it is, hasn't really, followed the law, or their interpretation was just really off, we can still make our own decision as well. So this really, for EB-1A, can also be an impact for those in drafting your petitions, but also considering if you do have to go to the point of suing, these will be good cases to kind of back you up on your lawsuit. So what it means now for those who are in the process, like I mentioned, this does not Majority, does not alter USCIS adjudications as a matter of policy. So USCIS has not said, like they did with Kazarian, that we're going to now, abandon Kazarian. They haven't done that yet. And it's a single court decision. So there's nothing that is requiring the USCIS to do anything outside of that, but it can be something to look at when you're evaluating your case. Not that you should still look at the step 1, step 2, but our thought is that you can also, in the case where you are actually preparing your case, be prepared to point out that, the standard should be that you meet 3 or more criteria. There should not be this final merits. But if you are in this situation where you actually did receive a denial, some of you may have already gone through EB-1 and you had this step 2 denial, you met 3 criteria, there's still an opportunity. You could challenge it in court as well. There's the timeline is pretty long, but you want to check with an attorney to see if that's a possibility. Another one would be considering that if in your denial, they talked about it was too long ago, it wasn't recent for your achievements. That's not something that's required. So that might also be an opportunity for you to consider refiling and arguing or even appealing. Not when I say appeal, I mean actually going to court. Usually appeals within USCIS are not very productive. They take a long time and they usually end up really in favor of the government. So that might not be the best route. And then the other thing is that if you have an RFE and they've accepted they've already stated in RFE, yes, you meet at least 3 criteria, but we don't really think you have shown the totality. Step 2, you haven't shown that you have risen to the top of your field. So again, this in response to that, you want to, of course, try to prove that, but you also want to point out what the court case said, that this is really problematic because they haven't really explained what the standard is for you to even meet step 2 as well. All right, so finally, I'm talked a little bit longer than I thought, but let me go ahead and talk a little bit about how you want to, again, address your petition if you're starting out thinking about applying. Again, as we talked about, the narrative is very important. What you want to do is to be able to paint that story for the officer because they have tons of applications. So it's really important, not only the evidence that you have, but your cover letter that talks about how that evidence supports your narrative. And, each criteria is a chapter. So again, build on each criteria as it relates to the whole story of your career. And then keep in mind, I always tell people, the officer is not going to know about your field. They do not have the expertise. Yeah, very unlikely that they do. They don't assign it to any particular person who has any expertise in your field. So treat it as if though you're talking to a lay person like myself who doesn't know anything about your field. Make sure that it's clear. And then if there's any issues like silence, when I say silence is never beneficial, if there's an evidence, if you look at the evidence and say, well, it could be read this way, or maybe it's not, doesn't fill in the gaps in terms of our timeline, those types of things, you want to address that and explain why it doesn't matter or it does matter, and what you have to, what other evidence you can give to show that there's not an issue with that evidence. And then we talk about the three-part narrative. So what you want to do is when you're looking at your petition, think about the background, explain who you are, what is your field. Again, the officer doesn't know anything about your field, so, or assume that they don't know. So who are you? What is your field? What is it that you do? And explain the field itself and what is your place in the field, in your profession. Talk about what that would mean typically to be extraordinary. I mean, because you have thousands of people working in the same field, what does typically someone do in order to stand out, and what does that mean? And you have presumably done those things as well. So again, position yourself relative to your peers, and this really also make the officer care about your story. Paint that picture again where you show how you have helped, or how your field is important, what it does to benefit society, anything like that you want to talk about. It's not necessarily national interest petition, but you do want to show, the benefits that you're going to bring. And that kind of goes into the third part, which I'll talk about in a minute. And then part two is the evidence. So that's where you're building again on those accomplishments, linking each exhibit and making sure that you show the context of the impact that you've had, and the recognition. And then finally, this is very much a part of it. You have to show your now it's not national interest. It's a little different. It's called prospective benefit to the country. So this is basically explaining I have all these, I've done all these things and I'm going to remain or come into the US, and I'm going to, using my background, using my skills, my accomplishments, my experience, this is how I'm going to benefit certain aspects or certain part of the US. How am I going to benefit that? So if you're in healthcare, you're going to talk about what you're going to do, conduct additional research, or help teach, or you're going to do something that's related to your field, because you can't be an extraordinary ability as a physician, but say you want to be a tech person or something like that. So you have to show how you're going to be connected and what you're going to do in terms of helping the US in certain aspects. So, and then lastly, I'll talk about the expert before I go into questions. We'll talk about the expert letter strategy. So a lot of people do, when we meet with prospective applicants, talk about how many letters do we have? What do they need to say? And, letters are important. They're not 100% of what the government looks at. And sometimes they do try to discredit letters. So you want to make sure that those letters are very strong, have at least one, I say 3 to 5 here, but sometimes you can do 1 or 2 depending on your field, but try to have independent experts that really have not collaborated with you. You also want to be sure that the letters relate to whatever criteria you're trying to prove. A lot of times it has to relate to major contributions, but it could relate to your critical role. It could relate to the awards you've won. So that letter should need to specify. I am talking about applicant and the work that he or she has done as a major contribution. And so they're going to be very clear about what the purpose of their letter is, and very specific about any impact that you have. And of course, the writer, the recommender should have good credentials. You want to be sure that they are able to provide their CV and show that they have actually accomplished a bit in the field as well. And so they have the expertise to make comments on your expertise as well. So as far as letters are concerned, we usually recommend no more than 7, so 5 to 7 at the most. You want to find those independent experts. You can definitely have people that actually have worked with you and can talk about your work. And if you can get people that are very strong in the field, very well recognized. You don't want too many of those, maybe one or two at the most, because sometimes the government tries to compare you with them. So you want to make sure you're getting that balance there as well. So those are the things that we want to talk about that we want to look at when we're thinking about who will be helping us, who will recommend us as eligible for EB-1 as well. So before we end, I want to go ahead and give an opportunity for questions. And I haven't looked at the chat, so I'll look in a minute, but I want to be sure that please do use your chat to ask questions. To give everyone an opportunity, please limit your questions to one. And again, protect your privacy, make sure the questions that you ask are very general in nature. And then we'll close with a few recommendations as well. Okay, so I think right now I see one question. So if you want to ask any questions, please go ahead and do so. We have a few minutes before we close, but I will answer the one question I see right now, which is, does RLA teachers with BA qualify? I'm not honestly, could you let me know I don't understand what RLA is. I think with the BA, I think you're talking about Bachelor's of Arts. So if you can clarify that for me. Sorry, I don't understand that acronym, but I will say generally that teachers, of course, would qualify. Any occupation would pretty much qualify as long as you can meet the criteria that we talked about. So if you can meet that criteria, providing we have actually worked for some teachers in the past, but they would have things like the awards. They would have some publicity about them, different things. So again, it would basically be determined by the criteria, even if whatever occupation that you're in. So there's another question about visa ban restrictions for certain countries like Nigeria. How does this affect the EB-1A approval and visa availability? And that's a good question. There are visa bans for many countries. There's 75 countries that are impacted, and some impacted in different ways. The 75 country ban is for those who are outside the US and eligible to get an immigrant visa, which is a green card. So an immigrant visa, that is the process where once you qualify for EB-1 or any other green card category, if you are outside the US and going to process at the US Embassy, that is the immigrant visa process. And there is a current hold on any approvals of those immigrant visas. So we have actually had clients who were approved for EB-1, have been waiting through the immigrant visa process. But unfortunately, this ban occurred. And so although they've finished everything as far as the process, they were told that they cannot actually get an immigrant visa until the ban is lifted. Now, for those who are inside the US, so if you're applying for the EB-1 I-140 petition, there's no ban for you to do that. You can certainly still apply. The question would be, because the government has put a sort of administrative hold on many applications from people from Nigeria and other countries. So while they will accept the application, put it into the queue, give you your receipt, even if you go premium processing, it's still possible for them to say, we're not going to make any decision until the ban or the restriction is done. Or lifted, because right now they're being told, yes, you can accept applications, but for nationals from these countries, you won't be able to issue a decision on those. At least, and practically, we are seeing some of that. There are some court cases again about this, trying to say that this is not lawful for the government to do this in terms of holding on applications. So we'll see how that goes. But in any event, yes, that is an issue, whether you're outside the US or inside the US. But if you're still at the first stage where you want to do the qualification of the I-140 stage, that's still doable. You can still do it. It's better if you are qualified now to go ahead and put that in, even if it does take time for it to be decided because of the hold. The question that someone asked here was about working with teachers. So thank you for clarifying language arts and reading. If there are some criteria missing, do you work with us to build the case? So yes, what we typically do if someone comes to us and we're evaluating whether or not they could meet the EB-1 criteria. And again, it's all our own evaluation. We have no guarantees of whether anyone is going to be approved. But in any event, if we feel like there are some gaps in your case, then we will recommend what you can do and to build on that. And then once you've built on that, we will reevaluate. And if you can have all the evidence ready, we will, be able to work with you on that. Another question follow-up is that any professional insights on when this ban can be lifted based on the court cases you missed? Unfortunately, it's so unpredictable because court cases are pretty much unpredictable as well. So unless, we don't know, courts will take their time. Usually they're a little faster than what the government has been, but it's just hard to say at this point. My understanding is, at least for some part of the ban, they're supposed to, the administration is supposed to reevaluate in June whether or not they're going to continue with these bans in itself. But it's very difficult to say. So if there's no further questions, I do want to end with some more information for you. So basically, as I mentioned, 3 things you want to remember today, you want to take from this session. Understand that the bar is high, but it is winnable. 67% approval rate is still a pretty good approval rate. So you want to make sure you focus on your strategy, anchor achievements, put evidence in context, and don't just look at 3 criteria. We always recommend try to do more. Try to get strong evidence for more than 1 criteria. You also want to, this recent court case that I mentioned is something that you want to keep in your pocket. Again, the government has not changed this process. It's still using step 2. But if your case is denied, you might also want to consider a challenge in court as part of your process. And so your petition is very important, again, that you build that story. Make sure that you tie in all your evidence to show why you are considered to be at the top of your field. And then finally, your next steps, if you have not applied and you're considering it or want to think about how to build on your profile, look at the criteria, think about what would be your top strongest criteria, your anchor achievement, what other things you might be able to do in order to improve, gather your evidence and those things. And you can certainly feel free to schedule a consultation with us and we can evaluate and help you determine if if you're ready now or if you need additional work to be done. If you have been denied before, recently, I would say in the past 2 or 3 years, you might, and if it was based on the fact that you met 3 or more, but the final merits wasn't met, you might want to consider potentially filing a lawsuit. With that, of course, meet with an attorney because a lawsuit is not an easy task to do, but it's something that you may want to consider. And then, as I mentioned before, we're expecting some changes in law with the government changing its rules. So it's possible that would happen. And in that case, you want to be sure to think about, if you're ready now to go under the current guidelines now. But keep in mind, even if the USCIS changes its rules, and it has often changed its rules over the years, it does not mean that, there's not a chance of getting approved. It may be harder, and we'll have to evaluate that as well. But EB-1 can still be a viable option then. I think I had, okay. Okay, someone asked about recording. Yes, we are going to have a recording as well. So that will end our presentation today. Again, we want to remind you that this is general information. If you need specific advice for your case, then feel free to reach out to us. You can contact us by either email, going to our website, or scanning this QR code, which I will also provide to you in the recording as well. So again, thank you so much for joining us today. We hope this was informative to you, and we wish you all have a great day. Thank you.